Okay, so just a quick one. My mother's getting dementia. Can she still make a will?
Well, it depends on how bad the dementia is. To make a valid will, you have to be what we call mentally competent. Now, you can be vague. I'm vague. And the question is, at what point vagueness becomes mental incompetence? If you're in any doubt, then you should probably have her assessed before she makes the will, because if you just go ahead and make the will without an assessment, you may run the risk that somebody, your sister who she cut out of the will, gets very upset and so on, and says, well, she wasn't competent to make that will. We had a case recently where we were approached by the sister. She visited her mother in the presence of her brother and sister on the Saturday, and Mum passed away late on Sunday. In the interim, there was a new will, and my client was absolutely horrified, of course, because firstly, her mother hadn't given any indication she wanted to create a new will, and secondly, the new will gave everything to the brother and cut out his two sisters completely. Now, the thing, of course, stinks to high heaven, and there's, the two witnesses are local neighbours, etc. So we'll be interviewing them, and so on. There's also the issue that Mum may not have had mental competence at the time because the son put enormous pressure on her, and she was a very unwell woman, as indicated by her early demise later that day. So, but if you've got a mother or a family member who you're unsure of whether they are mentally competent to make a will or not, you should try to make sure that you've got some evidence that they were by having them assessed. Also, people can. There's a number of different people who can do it. It can be done by a psychologist, it can be done by a psychiatrist, it can be done by an appropriately qualified social worker. The point about it is it's effectively evidence as to the mental state of the person involved. You also want your witnesses at the time to understand that Mum's okay, because she might not have been all that brilliant, 5 hours before, and she may not be all that brilliant 5 hours from now. But right now, she's mentally competent. The law accepts that mental competence is something that moves around a little bit, and if you've got evidence that from the two witnesses that yes, I spoke to Annie and she answered me, yes, she knew, and I said to her, love, do you realise what you're doing? And she told me yes, she understood, and she explained to me what was in the will, and it was all correct, blah blah blah. Then I'm sure that she was fine. That's very strong evidence. An assessment by a professional prior to that only adds to that. If you don't get any of those things, then you just make it a lot easier for someone to challenge the will and say that Mum didn't have the correct mental capacity.
Peter, just a side issue. I've got power of attorney over Mum. Can I change her will once she's gone to mention?
No.
Even with power of attorney, I can't say, well,
you can't change it.
The kids are
a
gone.
will is one of those documents that a power of attorney doesn't work to.
Even though I'm going to be executor when that happens in the power of attorney, the will stays the way it was done.
Yes.
Where she's now.
That's right. Once she loses mental competence, her will remains until she regains mental competence.
Any other questions at all while we?
Yeah, I've got a question about the superannuation, the binding benefits. What happens if, like you say, in that scenario, both parents die and they're kind of like cross beneficial?
If you
superannuation.
Yeah, if the binding death benefit nomination should say, like the will should say, I give my benefits to my spouse, but if they have died before me or they don't survive me by 30 days, then I give my benefits to my estate or to my children or whatever.
Okay, because my superannuation fund don't have that permission. They only allow one name. Okay, they don't say if. What's the alternative? They don't allow for that.
A lot of them don't. That's then they'll just go back to the trustee and give the estate.
Well, my assumption would be it would go to the spouse estate.
Now, if the spouse is predeceased, it doesn't go to the spouse's estate.
Oh, okay.
The spouse has to be living in order to take the property. That's obviously something that needs sort of being looking at, isn't it, really, from the point of view of the retail offer fund. I don't know why that public offer fund. I don't know why that's okay.
Which is first colonial first state.
Colonial first. No, there's it gives you. I thought it gave you a number of different choices. Yeah, I'll make note of that anyway.
Thank you. It's a good point.
Because I know even if you had your own self-managed superannuation fund, I mean, some people go as far as actually amending the deed and putting clauses in the deed. That way, there's absolutely no question asked, where it's concrete in the deed of the fund, and that way, it's dealt with exactly how you want it to be dealt with.